has been introduced just recently, means recent years, but it is a very important law to understand. Before RERA, there are many examples happen in which buyer has been fraud by the builders, and they have lost their hard-earned money. Friends, there was no any regulation in regards to any purchase of property transactions, and we have seen many cases in Gurgaon where all the buyers has been fraud by the builders, and builder has run with their money. So with the positive mode, central government has brought RERA into the picture. Friends, today's webinar has been totally kept keeping in mind only one object, that is what should and what should not be to understand by the buyer while purchasing the property as per the RERA law. We want to make aware the buyers to understand all the aspects of RERA, so that while purchasing the property, they can not be wrongly promised by the builder. Friends, we have the very honorable faculty in RERA law, Advocate Lokesh bhai, who is expert in RERA, and we thank CA Ashish Tekwani, who has taken pain to bring our honorable faculty on this platform. Now I request President of Income Tax Bar Association, Sri Dhuvin bhai, to give his brief speech.
Thank you, President. Good evening, everyone. I welcome all the participants and also welcome our today's eminent speaker, Sri Advocate Lokesh Shah ji. Today's topic of our webinar is benefit of RERA, law from buyer's perspective. In olden days, we have heard about the court cases for the to-sell deed for a single property, or builder have taken the money from the buyer since long back and still not giving the property, or not getting the sale deed name in the buyer's name. So after RERA law implementation, buyer's right and safety to buy the property is increased. So sir, we need to know more about buyer's benefit and safety in the details. Once again, sir, I welcome you.
I request CA Ashish Tekwani, Vice President of Income Tax Bar Association, to please introduce today's honorable faculty.
Thank you, Kartike bhai. It is my honor to introduce today's eminent speaker, Advocate Lokesh Shah. Lokesh Shah is a practicing advocate and a company secretary. He is the member of Bar Council as well as Institute of Company Secretaries of India. He is an expert professional into the field of RERA and has a vast experience of over 7 years in the real estate laws, corporate laws, and intellectual property laws. His area of practice includes real estate and corporate laws. He is also engaged into due diligence reviews, structuring of startup funding transactions, and actively working with most of the renowned real estate groups and professionals. His major achievements include that he has been authored an online real-time updated book on RERA Act 2016 with Gujarat RERA rules and regulations, just like MCA ebook. He has been recognized by ICAI WIRC in their special edition of journal on PCS Day, that is 5th June 2021, for exploring and excelling into an unconventional area of practice, that is RERA. He has delivered various seminars and written various articles on various topics related to RERA Act, rules thereof, at Ahmedabad ICA branch, ICSI Ahmedabad branch, Baroda chapter, as well as various study circles of ICI. He has accomplished the task of fast-track mergers, due diligence, and private equity investments for many startups. Indeed, it's our pleasure to have you amongst us.
So friends, today's webinar is different from all other webinars. We have kept it in a question and answer form, and that has been suggested by our honorable faculty. He mentioned to us around 20 to 23 questions, and by we'll take up the all the questions, and through questions he will explain us all the aspects of today's subject. So I request C. Ashish Tekoni. So can we start with the questions?
Yes, Kartike bhai.
So,
If any of the members also have questions, they can put it into the chat box, and later we'll ask our speaker to address the same. Lokesh bhai, do each and every project is required to be registered under the RERA Act?
So, first of all, good evening, everyone. Thank you, President AGFTC and ITBA, as well as Ashish Bhai, for having me here. And as you rightly pointed out, we'll more focus on a buyer's point of view first. And at the later stage, we might take out for 5-10 minutes that how we as a practitioners can also explore into this area, as well as what compliance and day-to-day routines required to be followed upon, so that it will be in the interest of everyone's out there. So the first question which came out is whether each project is required to be registered with RERA or what. So under the RERA Act, every project which is located within the planning area is required to be registered with the Gujarat RERA, and for the exemption, there is a minor limit that if the land area of the project is less than 500 square meters, or the number of units in a project are less than 8 or less than 8. So let's say if the land area is 400 square meter and number of units are 7, then the project is not required to be registered with the RERA. However, if my area of land happens to be 400 square meters, but my number of units exceeds 8, means like in a 400 square meter, if I'm building 10 units, then that project is required to be registered with the RERA. So in a RERA, both the terms of the land area of 500 square meters and number of units less than 8 needs to be fulfilled for exemption. And second exemption comes is if your project is outside town planning area or outside planning area. So majorly the projects which are covered into limits of the Gram Panchayat, they are the projects which normally be situated outside the town planning area, and hence they are also not required to be registered with the RERA. Now, how to determine that whether a project is into town planning area or not, or within the planning area or not? So that is a very technical aspect where if your commencement certificate, or in Gujarati આપણે કહીએ કે રજા ચિઠ્ઠી of the project જો એ ગ્રામ પંચાયતમાંથી આવતી હોય તો નોર્મલી એ પ્લાનિંગ એરિયાની બહાર હશે એવું એક્ઝામ કરી શકાય. પરંતુ જો રજા ચિઠ્ઠી ઉપર કોઈ નગરપાલિકા કે નગર નિયોજનમાંથી આવતી હોય કે નગર નિયોજનમાંથી અભિપ્રાય આપવામાં આવતો હોય તો એ કેસમાં એ પ્રોજેક્ટ પ્લાનિંગ એરિયામાં તો કવર થઈ જ જાય. ભલે ત્યાં ટીપી ના પડી હોય કે ડીપી ના પડી હોય, હજી ટાઉન પ્લાનિંગ એરિયા નોટિફાઈ થઈ ગયો હોય પણ હજી ટીપી સ્કીમ પડી ના હોય, પણ એ પ્લાનિંગ એરિયામાં તો આવી જ ગયું. So it is admitted into the planning area, and hence it requires to be registered with the RERA. And third exemption is the projects which were completed before 1/5/2017, because the Act came into force on 1st May 2017. So if your project has received BU permission or completion certificate before 1st May 2017, then that project is not required to be registered with the RERA authority. Here, another thing is completion certificate of the whole project. Like if you were having a project containing 4 blocks A, B, C, D, and you had received before 1/5/2017 a part BU for A and B block, but not for C and D block, then the project becomes ongoing project and is required to be registered with the RERA authority. However, if a whole project has been received a BU for all the 4 blocks, then only that project gets exempted from registration under the Gujarat RERA. So these are 3 basically exemptions based on the area, 500 square meter or number of units less than 8 if your project is outside planning area, and third, if your project is completed before 1/5/2017, then only it is exempted from the registration. Otherwise, all other projects are required to be registered with the Gujarat RERA.
Thank you, sir. The second question is an exemption is given from the registration only, or the whole RERA Act is not applicable to small project?
So here, see what happens is exemption is given only from the registration. Like under the RERA, there are various sections. Under various sections, section 3 speaks about registration. Section 31 allows you to file a complaint. Section 14 provides a structure defect warranty for 5 years from the date of possession. So what happens is, in this exemption is provided particularly from the registration only. But for rest of the compliance prescribed under the RERA Act, it is applicable to all the projects. So like that 5-year structure defect warranty, if that project is though exempted, but within 5 years, if there is any structure defect in the project, then the allottee can go before the RERA authority and can file a complaint, raise the dispute and get the same exempt. So exemption is but completely from the registration aspect only. The rest of all the compliances are required to be followed by the promoter, as well as all the rights are available to buyers under the RERA Act for buyers of such projects also.
Just a second.
How can
So, sir, what you want to say is that if any project is not registered under RERA, but still the buyers of that project has a complete right to go if they have been cheated to the RERA authorities?
Yes, definitely, sir. Even though my project is not registered, I can go before the RERA authorities and can make a complaint. Even like if your project is required to be registered and the promoter has not registered yet, still being a buyer, you can go before the RERA authority and make a complaint to make that builder register that project.
Thank you.
from where can we obtain the details of registered project under RERA?
So, sir, in the RERA Act is central act, but powers are delegated upon the state governments to establish the authorities to judge. So just like RERA, in a Gujarat RERA, we have Gujarat RERA website gujrera.gujarat.gov.in, where you can just go there and enter the name of the project or a promoter or a RERA number on the website, and you will be just give a search and you will find out the details submitted by the promoter at the time of registration with the project. Here there is no fees, like in MCA we even need to pay 100 rupees for the same, but however in a RERA we can get the details of the project completely free of cost. Here you can see that just by entering the name of Safal, there are various projects where Safal name is populated are available on the records. Just by clicking on a view more option, you can download your project's Raja Chitti, Plan Pass, then a brochure, the draft agreement for sale or sale deed or allotment letter formats, and everything which has been submitted to the RERA authorities by the promoter. So for any project or a promoter, just by entering the project's name or promoter's name or his RERA number, you can get the details of the project from the RERA website free of cost. And these websites of each state RERA authorities are working as of now. So like for whole India, like if there is a project on a Maharashtra, then you can go to MahaRERA website and similar you will be given a search option. So it is available pan India as on date.
Thank you, sir. Next question. What is the important information or details which I am entitled to obtain from the builder developer?
So being a buyer, it is very important question, because I should know what I should be entitled legally to get from the builder or to know from the builder while making the booking. So under the RERA Act, there is a specific section which says that while making a booking of the project, the promoter is required to pass on so and so information to the customer. So while you are having the booking, you are entitled to have the details. So like Raja Chitti, plan approvals, but stage-wise completion schedule of the project, okay, on which date or up to which time, up to which stage the project work will be completed, what will be the facility for the water, electricity, sanitation, and what are the amenities which builder is proposing to provide, or other services which builder is providing. All this stuff legally you are entitled to obtain from the builder while making the bookings with the promoter, and the builder is legally liable to inform you all such things.
So are there any list? What are the documents that has been required from to be taken from the builder?
Yeah, that will be covered in a question. I have covered one question where
Okay.
the whole series wise we will take it out. At which time, what document you will be taken about.
Right.
What care regarding the payments, to how and how the payment should be made, and to whom the payment should be made after application of RERA Act?
So basically, what happens is it might be possible that the builder is running 2 or 3 firms, but we should inquire under which firm or under which company the project is undertaken, and payment should be made through banking channels only in account of that particular firm only. Like if I am having A and B 2 firms and I am running a project into A firm and taking payment in B firm, that should not happen. So while making payments, we should also ensure that we make payment in the promoter firm wherein the project is developed. Because many times promoters, we just rely upon the promoters and take payment into different firms, and in case of disputes, they just hang up and says that these are all the loan amounts and we have not taken these bookings. And at that time, buyers comes to the risk. So we should ensure that we should make payment into the firms where the projects are developed and are made through the banking channel so that we can have the proofs of making the payments.
Thank you. The next question is, what are the important documents that the home buyer shall obtain from the builder developer so as to safeguard its interest?
So let's go with the series that how these transactions are executed. So first of all, when the buyer visits to the office of the promoter, then definitely we are given a brochure wherein the project specifications, amenities, layout plans, floor plans, how the units will be constructed, everything is mentioned. The first thing we should obtain is our brochure. Second thing we should have is, while making a booking, we should have that booking letter or an allotment letter. So that becomes a proof that we have booked a certain amount, we have paid certain amounts and a particular unit has been allocated or particular unit has been booked by us. Then whenever you make payments, you should obtain payment receipts from the builder as a proof of making a payment. Fourth, agreement for sale. Now under the RERA, there is a provision which states that promoter can take more than 10% of the unit consideration only after executing registered agreement for sale. So now builders are under obligation that they have to execute registered agreement for sale before accepting more than 10% amounts of the unit consideration. So while you are making payment of more than 10% amounts of the unit consideration, you should also insist to get the registered agreement for sale executed in your favor. Earlier, they used to do notarized agreement for sale, but after RERA, it has been compulsory on their part to execute the registered agreement for sales only. So in registered agreement for sale, various terms are already covered that this unit has been allocated in this much amounts. This is the timeline by which unit should be given a possession, delayed period interest. If possession is delayed, then how much interest will be paid by the builder, and if buyer makes a default in payment, then how much interest will be charged from the buyer. All these things are covered into that agreement for sale. So in case of disputes, this agreement for sales can be relied upon, and that requisite remedies before the RERA authorities can be claimed upon. Then after project is completed, we as the builder obtains completion certificate or BU permission of the project, we should have a copy of the same from the builder. When after obtaining the BU, the promoter is required to execute sale deed for us as we complete the payment of the all the units for unit consideration. We should get the sale deed executed in our favor. After that, while taking over the possession of the unit, we should have the possession letter. And after the possession has been handed over and society is formed, we should also have a society share certificate executed in our favor. So all these documents from time to time we need to obtain from the promoters depending upon the stage of the transaction.
Lokesh bhai, how can a buyer check the authenticity of the documents which have been provided to him by the builder or the promoter?
So as we see just on a RERA website, all this like allotment brochure, booking, this agreement for sale, sale deed, all these proformas while registering the project with the RERA authorities are uploaded by the builder on the RERA portal. So the documents which are given to you, you can even go on the website and download the same and verify the same. Like here you can say layout plan, land documentation, building plans, building structure, brochure. All documents are already uploaded on the website. What are the common amenities they have proposed? All such informations are already provided, location of the project. You just can go there, download all this stuff and verify what has been given to you. So you can authenticate the documentation from the RERA website itself. And it is free of cost.
So all
even
these
title report, title certificate, land documentation, the land purchase deed of the builder, all such things are already available on the website.
So for the members, I'm just showing that you can just click on any document, and once you click on that document will be downloaded automatically, and this is an authenticated document like we download from MCA website. So it is as authenticated as we have downloaded it from RERA website. Here you can go to promoter details also. So this is also available on the website, and you can go on the progress also. So this is the format of the website. Each project has you can search by name of the project or from the registration number if you are having. Karthik bhai, next question.
Okay.
Sir, you have asked about the RERA certificate of our society certificate, but sir, they are now giving certificate of service society. So what is the worth of that certificate?
So that's what I'm saying is service society, because while making while forming an association of allottee, they form it by way of service society.
Okay, so that is a worth. That certificate is whether worth or not. Like
yes,
old certificate.
It is worth because you are member of that service society. How you can prove it? If you have share certificate of that society, then only you can prove it. No, that I am member of this society.
Okay.
Because what happens is what service society is, what the concept of service society is, a particular entity is formed to render the required basic services of that common area amenities of particular project. Now, if you are member of that project, you should be member of that society. Then only you becomes a part of that particular society and entitled to have the benefits of the same.
Okay, sir. Thank you.
Thank you, sir. The next question is whether real estate agents, brokers also required to be registered with RERA?
Yes, sir. Now, along with the projects, even real estate brokers are also required to be registered with the RERA, and all type of advertisement or branding materials done by the brokers or receipts issued by the brokers are also required to mention the RERA registration number and RERA website. And now all the brokers should register themselves with the RERA. It is compulsory. Even promoters cannot deal with any broker who is not registered with the RERA. So if and even being a member, we should also insist to have a broker who is a RERA registered, so that in case of any disputes tomorrow, we can raise dispute against them also.
So do they have to also show that which are the schemes they are working for?
No, it's just like it's a registration for 5 years. Like I'm working as a Lokesh as a broker. So I need to register myself whether in my firm's name or my name with the Gujarat RERA, and my registration is valid for 5 years period. And before 5 years, after 4.5 years, I can renew it for further period of 5 years by making a payment of requisite fees.
So they are not
And
supposed to.
yearly, the brokers will also require to file the as on date half yearly returns. But system is proposed to be brought in by the RERA, wherein the yearly the brokers will also require to file their returns, wherein number of units of all the projects wherein they have dealt with are required to be submitted details of the same to the RERA authorities by the broker.
One of the most common question of the buyers is that what is the remedy available to the in case the builder or developer has made false promises or is not giving amenities or services as promised by the builder.
So as rightly said by you, it is like very common and you can say very known phenomenon for all of us, that builders just to sell the units makes various commitments into brochures and orally also, and by trusting them we put lot of hard-earned money, but ultimately while having a possession or later we turn out that all such were just a bullshit commitments and nothing has been constructed or nothing has been given to us. So in such scenario, the RERA has given us various remedies wherein we can file a complaint before the RERA authorities along with the supporting documents, and RERA authorities, just by following the process of quasi-judicial courts like ITAT and everywhere, they also issue notice to the promoters and hearings are held, and even in certain cases RERA also orders or sends the site engineers to visit the site and verify the facts and details, and then based on that RERA directs the promoters to provide the missing amenities or to fulfill the commitments made by them, and in case such commitments are not fulfilled by the builders, then even buyers can claim compensation from the builders by filing a complaint before the RERA authorities. So now, after the RERA Act has came into force, civil courts have no jurisdiction to entertain any complaints arising between the buyer and buyers and promoters. Now it is compulsory for us to go before the RERA authorities only. Civil court में हमें jurisdiction જ નથી. So just like SEBI for the listed matters, IT department and ITAT for the income tax matters, we have special jurisdictional authority to deal with the disputes arising out of real estate transactions between the buyers and builders. If there is a dispute between two partners of the firm, which is promoter, then RERA will not come into picture. But if there is a dispute between buyer and promoter, then the RERA authority has been given all the powers to adjudicate such disputes, and buyers are at a liberty given the rights to raise their dispute before the RERA authorities by filing the complaints and claim the missing amenities or claim the compensation in lieu thereof.
Ashish bhai,
What is the what if the promoter wants to change the project plans after they have been passed?
So what happens is, under the RERA, under section 14.3, there is a provision which states that once the promoter has approved their plans and now they are revising their plans, so the promoter can revise their plan only after obtaining consent of at least 2/3 members of the project. So what happens if the promoter, after having a booking of 100 units, now deciding to make change in the project, then he need to obtain at least consent of 2/3. So you can say 67% of the members from which unit has been booked, and then only he can revise the plans. Unless and otherwise this consent has been obtained, the promoter cannot revise their plans. And now even like AMC, ORDA, all such planning authorities, while processing the files of revised plans, ask to the promoters to submit the copies of such consents, and only after such consents are verified, the revised plans are approved. And even like once the registration is obtained, like earlier I registered my project with 80 units, and now after revising my plans, the project is now my 100 units. My plans are revised, and now I'm constructing 100 units. So I also need to submit the project alteration application to the RERA authorities, wherein they verify whether such consents are obtained and whether all such documents and revised plans are in line with the GDCR and everything. And then the new RERA number, revised RERA number, is allocated to the promoter. So without the consent of at least 2/3 members, the promoter cannot revise the plans. However, if due to revised plan, there is a change in a particular unit of the project, then the consent of that unit holder is compulsory. So like if there is a scheme of a bungalow, and due to revision of plans, there is a change in a particular bungalow also, or a structure of that bungalow also, then that consent of that bungalow holder is compulsory. Then it is not optional. However, if there is an overall change in the project, not affecting the unit which has been already booked, then only the consent of only 67% of members are required. But if there is a change in a particular unit and that unit is already booked, then the consent of that particular unit holder is compulsorily required before going for revision of the plans. And in case if it is not taken, then definitely you can go before the RERA authorities to file the complaint and raise your dispute and get the same judged and solved.
Thank you. The next question is, what can I do if there is any structural defect or poor quality of construction done by the promoter?
So this is also a very basic question, because what happens is just after taking over the position, we come to find that there are various issues relating to construction quality, like leakages in very short span of 3 or 5 months, or various other like wood door frames are not properly installed, various small issues which we not be able to verify unless and until they are used, the units are used. So under the RERA, there is a provision which states that the promoter is required to remove any structural defect or any defect arising out of workmanship defect or a poor quality of construction for the period of 5 years from the date of possession. So it's not from the date of BU. Date જ્યારથી તમે possession લીધું છે ત્યારથી 5 વર્ષ. The builder is, if there is any structure defect or a defect in the workmanship or due to poor construction, there is any defect in the unit arising out of that, you need to intimate the same to the promoter, and the promoter is required to repair the same within 30 days from the date of intimation without charging any cost for the same. Like 30 દિવસમાં without charging any cost, the promoter is required to repair the same. And if it is not done, you can raise your dispute before the RERA authorities and get the same done. So the period starts from the date of possession for the period of 5 years. Any issues relating to the structure defect or workmanship quality or poor defects or poor workmanship or poor quality of construction or poor material usage and everything, you can file your complaint with the RERA authority. Builder is not resolving the same, and you can get the same done. Even you can claim the compensation for the same, like koi issues હતા, builder nata કરી આપતા અને આપણે કરાવવું પડ્યું, and you have the respective bills and everything, and you have proper communication made before the builder, but the builder did not respond and everything, we have sufficient proof, then we can definitely raise the disputes between the before the RERA authorities for the same and claim the compensation or reimbursement of the same.
Next, another pertinent question to various buyers is that what is the remedies available to buyer if the promoter fails to comply or does not give the possession of the apartment or building, as the case may be, as per the terms of the agreement.
Yeah. So the delayed possession of the unit is very vital question every buyer faces, because the promoter makes a commitment of 2 years or 3 years, but it takes almost more than 4 years to get the same. So while executing agreement for sale or making the booking letter or allotment letter, the builder is required to mention the date of possession by which the possession should be given to the buyer. So while executing this agreement, do ensure that the date mentioned is the date which he is committing to you. Because orally તમને 3 વર્ષ છે પણ agreement માં 5 વર્ષ લખી દે, એવું બી ના થવું જોઈએ. So do ensure to check your agreement for sale before executing the same or signing the same. And if by that date the promoter fails to give you the possession of the unit, you can have 2 remedies. You can claim refund of the whole amount paid along with the interest from the date you make the payment. So જો તમારે continue ના કરવો હોય એ પ્રોજેક્ટમાં, as the project is already delayed, you can claim refund with the interest before the RERA authorities. Second option, if you want to continue in the project, then you can claim the interest for the delayed period. So જ્યારથી તમને possession commit કર્યું હતું, the date from which the possession was committed till the date actual possession is handed over, you can claim interest for the delayed period. Now the question comes, interest rate, કે કયા rate interest મળે. So if the rate of interest is mentioned in the agreement for sale, કે ભાઈ builder in case of delayed possession will give you X% of interest, then that rate of interest will be payable to you. Otherwise, if there is no such specification is done, then State Bank of India's MCLR rate plus 2%. એટલે જે MCLR rate prevalent હોય એના plus 2%. Now here and another catch comes is, what if the builder has mentioned that in case of delayed period, buyer have to pay interest at the rate of 15%, whereas in case of delayed possession, builder will pay at the rate of 10%. So it is not allowed by RERA now. It is clearly written under the act that the rate of interest payable by the buyer to the builder should be the same at the rate which the builder takes interest from the buyer. So now, if builder is charging 12% or 15% to you for the delayed payment, you will be entitled to take the interest at the same rate for the delayed period. Also, additionally, if you are claiming refund, then the interest shall be payable from the date from which you have made the payment.
What are the remedies available to home buyer if there is defect in title of the land on which project is situated?
So basically, like every builder takes a land title before starting the project. But afterwards, if you find out, if it comes out that as land disputes are such that runs to years on years in the courts, so after that you have booked the unit, if there is any dispute arises in the title of the land, then in such case, you can definitely go before the RERA authority and claim the refund of your amounts, or you can claim the interest for the delayed, or because if there's a issue in the title of the land, then the promoter will not be able to give you the possession of the unit, or the possession will be subject to that defect in the title. Or the common area, જ્યારે સોસાયટી બનાવીને સોસાયટી હેન્ડ ઓવર બી નહીં થઈ શકે, because there is an issue in the title of the land. So in such cases, it is advisable to exit from the project, and you can go before the RERA authority and claim the compensation for the same, as well as refund of your amounts paid to the builder as well.
Thank you. Next question is how the transfer of the project from the current developer to a new developer will have impact on my booking transaction.
So this scenario normally do not comes in day out system. But what happens is, let's say initially I started my project, and after 1 or 1.5 years, I took some bookings, certain bookings, I did certain amount of work, and then due to some reason I want to sell this project to new builder due to any reason. Then there are two things which has been prescribed under the RERA. The builder, existing the developer, cannot transfer the project without consent of at least 2/3 members. Second, the upcoming promoter, the upcoming new developer is required to complete the said project within the same timeline, and all the responsibility of the current developer or liabilities of the current developers will be passed on to the new developer. So like if old developer had committed to provide me unit within 3 years, then new developer cannot come and say my 3 years start from this date. His 3 years will start from the old date only. And if within that date I'm not getting my possession, then I will be entitled to claim the compensation or interest or refund with the interest, whatever I choose to, from the new builder. Normally such scenarios occurs in the cases where the project gets stuck. that હવે એક્ઝિસ્ટિંગ બિલ્ડર જોડે પૈસા નથી અને પ્રોજેક્ટ કોઈને વેચી દેશે, અથવા પ્રોજેક્ટ ફાઇનાન્સના કેસમાં પ્રોજેક્ટ ફાઇનાન્સ ભરી શકવાના કારણે બેંકે પ્રોજેક્ટ ટેક ઓવર કરી લીધા છે અને હવે બેંક પ્રોજેક્ટ કમ્પ્લીટ કરી રહી છે. તો એ કેસમાં જે એક્ઝિસ્ટિંગ બુકિંગ મેમ્બર્સ છે એમના રાઇટ્સ અગેન્સ્ટ ધ ન્યૂ બિલ્ડર્સ આલ્સો અરાઇઝિસ અંડર ધ રેરા.
What are the provisions relating to formation of association of allottees by the promoter under RERA? Can an individual allottee claim compensation for common areas deficiencies?
So common area means જે આપણા પ્રોજેક્ટની amenities છે અને જે land છે જેના ઉપર the land on which the project has been constructed upon, so the part of the common area and amenities which are undivided proportional share of land, the ownership of that the same rests with the association of allottees. Now under the Gujarat RERA has specifically done a circular wherein now association of allottees can be formed by two ways. Either it can be a cooperative society registered under the Cooperative Societies Act 1961, or it can be a company incorporated under section 8 of the Companies Act 2013. So earlier days where non-trading corporation act ની અંદર association બનાવતા હતા, or welfare association under section under 1860 act જે બનતા હતા, now all this has been done away with, and only cooperative society can be formed or a section 8 company can be formed. After the BU is obtained, within 3 months, the promoter is required to transfer the ownership of the common area and amenities to the society or the association of allottees, and have to hand over all the documents of the project as well as the details of maintenance amounts taken, maintenance deposits taken, and transfer that maintenance deposit to the society's account, and hand over the maintenance on management of the project to such association of allottees. એટલે જે સોસાયટી બની હોય એને મેન્ટેનન્સ મેનેજમેન્ટ હેન્ડ ઓવર કરી દેવું પડે, and after that no જે બી future FSI ના rights હોય or any income arising out of such common area and amenities, all such goes to the society only. So like society બનેલી હોય એની ઉપર ટાવર ઇન્સ્ટોલ કરેલું હોય, સોસાયટી મેન્ટેનન્સ મેનેજમેન્ટ સોસાયટીને હેન્ડ ઓવર થઈ ગયું હોય, તો એની જે રેન્ટની ઇન્કમ આવતી હોય એ બી સોસાયટીને જ મળવી જોઈએ, એ બિલ્ડર ના લઈ શકે. So the common area amenities waste with the association of allottees, and the promoter is required to transfer the same within 3 months from the date of obtaining the BU, unless otherwise any other date is agreed upon between the members and the promoter. So as per RERA, 3 months is the guideline, unless otherwise there is any other date agreed upon you and the promoter. And after that, all the future FSI rights, like ઘણા બિલ્ડર ભલે અંદર અગ્રીમેન્ટમાં એવું લખતા હોય કે ભવિષ્યની FSI ના રાઈટ અથવા ટેરેસ રાઈટ્સ અમારા રહેશે, but it is not legally valid. After association is formed and handover is done, all the future FSI rights of the common area, amenities, terrace, everything rests with the society and society members only, and not with the promoters.
Sir, 3 months from?
3 months from the date of obtaining completion certificate, that is BU.
Okay.
But what happens is, there is another act, that is Gujarat Ownership Flat Act, GOFA Act. It is also prevalent in the Gujarat, and in the RERA it is mentioned that unless otherwise any other date agreed upon, એટલે કે સમજો બિલ્ડર અને મેમ્બર્સ ની વચ્ચે બીજી કોઈ એવી ડેટ અગ્રી ના થઈ હોય તો 3 મહિના. પણ સમજો મેં તમને પહેલેથી જ અગ્રીમેન્ટમાં જે ડેટ લખીને કમિટ કરીને આપેલી હોય કે બાય 31 ડિસેમ્બર 2025 સુધી અમે સોસાયટી મેન્ટેનન્સ મેનેજમેન્ટ કરીશું અને પછી મેન્ટેનન્સ મેનેજમેન્ટ તમને હેન્ડ ઓવર કરીશું, તો પછી 31 ડિસેમ્બર 2025 will be the date.
Thank you. Next question is, can an individual allottee claim the compensation for common? I think it is covered.
So just I covered it again. So
Next.
what happens is, common area amenities જે છે એના ownership rights rests with the society only. So it is preferable that any compensation or any defect જે common area amenities માં રહેતી હોય, all these complaints if are raised by in the name of society, then it is preferable. But in case of compensation, individual allottee cannot go and claim compensation for the whole common area of the project. So it is preferable that all such kind of complaints should be filed in the name of society. However, by filing an individual allottee's name having authorization from all the society members, it can also be workable option.
Can I challenge the order of RERA authority?
Yes, definitely. Like if you have filed a complaint before the RERA authority and you are not satisfied with the outcome of the same, you can file complaint with the RERA Real Estate Appellate Tribunal. That is just like ITAT, Income Tax Appellate Tribunal. There is a Real Estate Appellate Tribunal. So you can file appeal within 60 days, 60 working days. તમને order મળ્યાના 60 working દિવસમાં, 60 days from the date of receipt of the order, 60 working days, you can go and file appeal before the RERA Appellate Tribunal. And even if you are not satisfied with the order of the Appellate Tribunal, then you can directly move to High Court within 60 days and then Supreme Court. So this is the hierarchy within which the grievance redressal mechanism of the RERA under the RERA Act operates.
Thank you. Next question is, how much cancellation charges a builder can charge as per RERA?
So under the RERA Act, there is no such specification that a builder can charge 10%, 5%, 20%. However, under various judgments or various case laws, and there is also one Supreme Court judgment, it has been stipulated by the court that cancellation charges cannot be the unreasonable or exemplary. So a cancellation charges should be reasonable, like 2%, 5%, 10%. So till date, in various cases, maximum cancellation charges has been allowed is 10%, not more than that. And 10% is also of the total amount received, not of the unit consideration. And just before a day before, Maharashtra RERA has came out with a circular wherein they have prescribed the format of allotment letter, and in the allotment letter itself they have limited these charges of limit on the cancellation charges, wherein they have allowed maximum 2% of the unit value as a cancellation charges, not more than that. So like even if you are cancelling and the builder is charging cancellation charge, then you need to check two things: whether cancellation is due to your default or builder's default. Like if you have waited for 3 years, builder committed 3 years, agreement માં 3 વર્ષની date લખેલી છે, and now as builder has failed to give you the unit within 3 years, you are legally entitled to cancel the unit and get the refund of whole amount paid along with the interest. Then the builder cannot charge the cancellation charges due to his default. Now let's say you don't want to continue in the project due to some reason like money issues, or you are now not willing to continue in that project and you want to book in another project, or you have changed the location, or due to any reason, if you are not continuing in that particular project, then only the builder can charge the cancellation charges, and that too as per the terms agreed in the agreement for sale, and that should be a reasonable charge. That should not be the exemplary cancellation charges. Even if it is written in the agreement 20%, builder cannot, you can definitely go before the RERA authority and get the same reduced. Ashish bhai, mute hai.
Okay. How does the complaint redressal mechanism operate under RERA?
So just as we discussed, first there's the RERA authority where we can file a complaint. Under RERA authority, there are two codes. One is an authority, second is an adjudicating officer. When you are claiming a compensation for any defect in a structure due to structural defect, or any deficiency in the service due to brochure, like brochure માં કંઈક બતાવ્યું તું ને તમને આપ્યું નથી, अथवा due to any structural defect or poor workmanship quality, you are claiming compensation only, then you need to file complaint before the adjudicating officer in form B. Whereas any other complaint like refund with interest, or a refund of the amounts, or reasonable cancellation charges, or repairing work, or amenities provide karai yape, all such kind of complaints, that is other than compensation, all complaints are required to be raised before the authority in form A. So the fees for filing the complaint is 1,000 rupees only, government fees, and the complaint is required to be filed before the RERA authority in a requisite form, whether it's a form A or form B. And after the order is received from the RERA authority, if you are not satisfied with the same, you can go to the appellate tribunal, and after that within 60 working days, after that High Court within 60 days, and after that Supreme Court. So this is how the grievance redressal mechanism under the RERA Act operates.
शिवम भाई, वाइस प्रेसिडेंट सदन जोन ने म्यूट करो.
सर मैंने कीधु करे छे.
Thank you. The next question is शिवम भाई जरा म्यूट करो यार. श्रीधर भाई
કરું છું એક સેકન્ડ.
થઈ ગયું છે. We can proceed further.
The next question is how to file a complaint with RERA authority and what is the fees for the same.
So there is clearly an online mechanism wherein you can file a complaint. The format is just like authority ma complaint file karwani, so this is the form A wherein you need to, this is the format wherein you need to fill in the requisite details, and this is the point wise you have to fill in all the details, and along with this you have to attach all your requisite documents and upload the same on the RERA website, or you can file it in an offline mode also. Along with this, you need to attach all your documents or supporting evidences like booking form, agreement for sale, payment receipts, everything you need to attach, and need to submit the same with the RERA authority. There is online mechanism also wherein you can upload everything and take the fees of 1,000 rupees, and your complaint is registered before the RERA authority.
Can I file a complaint with RERA authority if the case for the same is pending in any other court?
So what has happened is there's a like on 1/5/2017, this act came into force. So as on that day, it might have happened that your case was pending in a civil court against the builder, or might be under the Consumer Protection Act before the Consumer Court. So in such cases, there is a specific provision under the RERA which states that if your any matter which is covered under the RERA Act is pending before any other court for determination, then you can withdraw the same from that court and then only file the same before the RERA authority. You cannot, without withdrawing from that court, you cannot come to the RERA authority. Otherwise, it will result into the same matter running into two different courts. So you need to first withdraw from that court, and then you can definitely file the same before the RERA authorities.
Okay, thank you. The last question is, what is the time taken by the RERA authority in adjudicating a matter and dispose of the same?
So practically under the Act, it is written 60 days, but it does not happen because it is just a centralized court across the Gujarat na બધા matter એક જ જગ્યાએ ચાલે છે, and there is a there are very issues in operating of the RERA authority itself. So 60 days though Act writes the same, but normally it does not take 60 days, it takes more than 6 months minimum. But they have to pass a result order for the delay. And normally what happens is if the builder responses or both the parties responses and appears before the RERA authorities timely and the submissions are made, then within 6 to 12 months, the orders are passed by the RERA authority normally. However, depending on the matters, or time taken may ranges to more than a year also.
So first of all, I must congratulate sir, and thank you for selection of very informative questions, and really we enjoyed all your answers, and we got the basic knowledge about RERA. Now I request Honorable Secretary of ITBA C.A. Sridhar Shah to please take up the questions mentioned in the chat box.
Thank you, Karthikeya. It is my request to all the participants, if they are having any question, they can raise hand as well as can post the questions in the chat box. I'm reading the questions posted in the chat box. First question is from very early, even before the webinar started, it might have been answered. The question is it necessary to get approval for sale deed? Is it necessary that all sale deed be in same format? If the top floor flat buyers are given the rights of terrace and have been charged, whether the builder can deny, give it in writing? These are three questions that were posted. Yeah.
So the first question is it necessary to get approval for sale deed? So while registration of the project, the promoter is required to submit the pro forma of agreement for sale deed and allotment letter, which he will be executing with the buyers. So already that pro forma of sale deed is given to the RERA authority, and RERA authority verifies the same, that whether the same is in line with the RERA provisions or not. And after only that, the registration is granted. So approval of sale deed, so it's a yes, draft of sale deed is approved by the RERA authority and it is available on the RERA website for search. Second, is it necessary that all sale deed be in the same format? 100% it is not possible to execute the same in the same format, because it might have happened that minor corrections are made by the builder in the execution. However, any such clauses which has been added afterwards, which are in a contravention or provision of any law, not only RERA law, any law, because if it is not allowed by law, then you can, even if it is written in the agreement, it is not binding to the parties. So any such terms included in the sale deed or agreement or any other document which is not allowed to be written under the law, or it is one-sided, like it is favoring only one party and not the other party, then the parties to the same or the buyer cannot be made binding to that terms. So even if it is written in the agreement or alteration is made, you can definitely raise a dispute on the same and say that it is not binding to me because it is against the provision of the laws. And third question, top floor flat buyers are given the right of terrace and have been charged. Builder can deny, give it in writing. Definitely he will deny because the top floor part is not taken in the consideration while calculating the FSI area, and it is a part of the common area, and no builder can save the common area. Penthouse is a different thing, but the top floor common terrace cannot be sold by any builder to any user because it is a part of a common area, and common area amenities, common areas ownership rests with the society or the association of allottees, and the builder cannot sell the same. There are various Supreme Court and RERA authorities judgments on the same.
There is another question that in case consent for project alteration when builder has already taken consent in ATS or sale deed, whether separate NOC is required.
So what happens is RERA authority has already taken prescribed their own format to have the consent. So while going before the RERA authority specifically asks us that you provide us consent in this format, not in the ATS or sale deed. Sale deed to question it nahi aave because if already sale deed is done, that means there is no revision after that. સેલ ડીડ બિલ્ડર પછી જ કરશે, બધા પ્લાન રિવાઇઝ થઈ જાય, બધું જ થઈ જાય, હવે ફાઇનલ આઉટકમ છે અને હવે કોઈ ફર્ધર રિવિઝન નથી, then only the builder will execute a sale deed. However, ATS can be done upon, but after it, RERA will definitely insist from the promoter while verifying the file to obtain the consent in the format prescribed by the Gujarat RERA only.
Can a buyer ask for a supplementary sale deed after the sale deed is executed for any left out terms?
So you cannot term it as a supplementary sale deed. Actually, if sale deed is done, તો sale deed માં standard format માં એવું બધું લખેલું જ હોય છે કે ભાઈ બધું ઓકે છે, everything is okay, you have verified, possession is given, you have checked, nothing is left out. But if there is something pending and sale deed is executed, then a separate agreement mentioning everything can be executed upon, or in that sale deed itself you can mention that this is pending, which is required to be completed within so and so timeline, and then only possession will be handed over or taken over. So that thing comes on the paper itself. Otherwise, it might be taken to use it against you while presenting the case before the RERA authorities. ત્યાં તો પછી બિલ્ડર એવું જ કહેવાનું કે સાહેબ બધું ઓકે છે ને અમે ચેક કરીને બધું આપ્યું છે ને એમની આમાં સહી છે. So it is possible that કે afterwards આપણે પછી એને સ્ટ્રક્ચર ડિફેક્ટ માં કે પેન્ડિંગ વર્ક્સ માં we can raise a complaint and we can have the site visit from the RERA authorities, we can produce the photographs and it can be proved upon, but it is always advisable to go safe from the first instance itself.
I think all question has been completed. Okay, there is a new question.
There is new question.
Hey, there was one question was top floor allottee is given terrace adjoining. The answer is already given, sir. Another is whether NOC is required in case part project alteration post BU.
So part BU has been already obtained, and after that alteration is happening in the project, due to which I will definitely suggest to take the consent, because what will happen is if due to alteration the number of units are increasing or common area amenities are changing, then definitely it will affect the rights of the allottees of all projects, not the remaining projects only. So even if it is the part BU is obtained, the rights of allottees of that blocks will also get affected due to revision. So it is always advisable to take consent of that members also, because while calculating 70%, 70% of the whole project is required to be calculated, not only the proportion of the revised plans only.
Sir, there are two messages. One is saying excellent, another is saying very interesting discussion, really increasing my work. People have uploaded your sharing of knowledge. Thank you, sir. I think
Sridhar,
yes, Ashish,
there are two questions. Lokesh bhai, regarding we have a overview of RERA from the perspective of the buyer. Now, what are the scope of work which are available to professionals like us in RERA? Just we can, if have a brief idea about that in short, so that few of the members can know, because it is an upcoming practice area, and as you have in your given in your introduction that you were practicing CS and then you have come into advocacy field. So what do you see as the future of practice in RERA? That is one of my question for the benefit of our members. And also, is insurance required to be taken regarding the projects, regarding the land title, etc., and how much effective that insurance is?
Okay, so let's first go into reverse mode. We will cover insurance first. So insurance is the already guideline of the GDCR norms. As per GDCR norms, while obtaining BU permission, they have to take the insurance of the building itself. Now what they have done is, while obtaining a BU, the engineer is required to certify the cost of the building. The promoter is required to take the insurance of that amount and submit that insurance policy while obtaining the BU permission. And then only the BU permission is granted. Now what happens is, what builders does is they take this insurance of 1 year, 2 year or 5 year maximum. After that, it becomes a society of, that becomes a responsibility of the society, because ultimately that property or ownership, it is already transferred to the society. But as builder himself does not make members aware about it, and there is very less awareness on this system. In Gujarat, normally no society has taken the insurance of their building. But definitely there are norms on the insurance part also, and now we have seen that slowly and gradually what is happening is, earlier what builders used to do is, if their actual project cost is 8 crore, even though the engineer will certify 3 crore, 4 crore and will take insurance of that value, because they have to pay the 1% labor cess on that amount while obtaining the BU. So what happens is, if I certify 8 crore rupees and I certify 4 crore rupees, on a 1%, I save almost fees of engineer itself. So they take insurance of lesser amount to save that labor cess amount also. But now slowly and gradually the practice is taking place, wherein while registration of the project and during the project returns and everything, project cost is already submitted to the RERA authorities. So they take the base of that project cost, and based on that, that insurance is insurance requirements are determined, and promoters are required to take insurance of that amount. But it is not 100% yet verified by the authorities, but some of the places I have seen this. So I'm expecting that down the line 2-3 years, this checkpoint will also come into the picture. And apart from that, there is a provision into the RERA also that the promoter is required to take insurance of the land of the title. That is under section 16. However, what is happening there? Insurance companies do not have such product guaranteeing or giving the insurance of the land titles, because revenue records itself are a big issue in our country. And in our country, the revenue cases ranges to 5 years, 10 years, 15 years, 20 years. Like after 50 years, even the people comes and files a case for the old, like 50-year-old or 70-year-old land. So like even insurance companies can't verify whether title is clear or not. Only HDFC Ergo, when RERA Act came after a year or so, HDFC Ergo in year 2018 came out with a title insurance policy, but the premium of the same starts with the 50 lakh rupees. So no builder takes it, and no RERA authority verifies it because there is no product. So the RERA authority cannot force it.
And regarding what are the professional opportunities available under RERA Act for professionals?
Sorry. So now let's come to our part. So basically, let's discuss RERA into brief that okay, if I am a promoter, so what are the compliance I basically required to execute? So first, as soon as I obtain my commencement certificate and plan pass, I need to register my project with the RERA authority. Unless and until I register my project with the RERA authority, I cannot advertise, book, sell or market or invite any person to book or subscribe to my units in project. So unless and until project registration is done, a promoter cannot advertise, market, book or sell. So first stage is registration. For registration, there's a requirement of architect, engineer and CA certificate. Apart from that, there's also requirement of title report and that all this agreement for sale, sale deed and allotment letter drafts. So here, being a professional, you can form and develop an entity. You can prepare the Form 3 CA certificate based on the tally data. You can do the accounting. We are already doing for many clients. You being a professionals, income tax professionals, you are already doing accounting for many clients. So you can even prepare that CA certificates. Being a chartered accountant, you can even certify the same. Apart from that, this legal work, if anybody is exploring into agreement for sale deed, drafting and execution work, you can get the same done. Apart from that, for every builder, like if he is doing 100 units construction, he will definitely go for a project finance, or this 100 units out of 100, 90% buyers will go for home loan. So you can even go for APF and home loan work. So like from starting from forming the entity, getting PAN card, GST, income tax, RERA CA certificates, all such kind of legal works, anything and everything, being a professional, we can do. So if there's a one builder comes to you and he handovers you complete project to do every task, just determine the ticket size of the client. Second thing, once the registration is done, every 3 months, the promoter is required to file the RERA returns, wherein he need to submit the progress of the project through architect, engineer and CA certificate. So here also again CA certificate comes into picture. Apart from that, there is a yearly annual audit. Just like income tax audit, there's a RERA audit, which needs to be submitted by 30th September, but as 30th September સુધી તો બધાના audit જ complete નથી થતા, it normally gets extended to the October or December. Last year due to COVID, it was extended to the 31st March. Apart from that, you do audit, you do returns. Under the Act, if any complaint is filed before the RERA authorities, then a chartered accountant in practice, a cost accountant in practice, a CS into practice, or an advocate can represent that complaint before the RERA authorities on behalf of the client. So you can, being a chartered accountant in a practice, you can even appear before the RERA authorities in the litigation matter, just like an advocate. So it's just like a bundle of opportunities or a bundle of ocean of the opportunities before us being a professional. It's up to us how much area we decide to explore into. And if we start, see, all majority of you are already senior to me. So once we start exploring the same, it takes 6 to 12 months time, but slowly and gradually, definitely we get the hold on the same. So there are bundle of opportunities for the professionals into this field. Apart from this, like all due to this litigation work. Apart from that, these insurance policies are already given by some of the insurance agents, which already we know. So we can give the builder a whole bundle of back office service that you can outsource your back office to us. You just construct and sell the same whole back office from start to end. Even like society formation can be done from our side. There are standard bylaws available from the department. We just have to, standard checklist is available, just have to execute the same, get the same signed and submit the same into department and get the thing done. And even society registration માં તો government ની 0 રૂપિયા fees છે. Government ની તો કોઈ fees બી નથી. પછી એ society ના બી regularly accounting, audit અને tax returns, TDS returns નું કામ મળી શકે. So there are bundle of opportunities starting to end available to us. Now it is up to us how to explore and which area to cover up. Like it is not possible for everyone to catch up everything. So like somebody might be explore into accounting only, somebody might explore into GST, income tax work only, somebody might explore into RERA or litigation only, somebody might into litigation only. So it's completely on to us. So like registration, return filing, annual audit, litigation, all such areas. Apart from that, redevelopment, because like everyone is either આપણી સોસાયટી રીડેવલપમેન્ટમાં જવાની હશે, કોઈ આપણા રિલેટિવની જવાની હશે. Everyone knows about it, but nobody knows the guideline on the same. Now RERA Act also becomes applicable to the promoter who is doing the redevelopment work. So even such cases, like in redevelopment case also, if there is a developer has not developed in the timeline, like 18 મહિનામાં commit કરીને જેટલા existing member ને possession આપવાનું હતું પણ એમણે નથી આપ્યું. So in such cases also the matter will go into RERA courts only. So again, it is a very good area of practice where every member can explore the same. However, it is such area, it is very new, like it came into effect from 1/5/2017. ગુજરાતમાં રેરાની વેબસાઇટ 10/7/2017 થી ચાલુ થઈ. And then as GST came on 1st July 2017, GST had like 2-3 years to GST charges. So nobody had time to explore something else. But now after GST has settled and many, it will never settle, we know this, because in India no law settles. Even after 30 years, 40 years, 50 years, new things definitely comes upon. But RERA does not have that much of changes yet. So definitely everyone can cop up upon that and can start exploring the same. And this is very good area. I used to like I had the COP of being a company secretary. I had COP of a CS. I had also done LLB at that time. But being a CS, I started exploring it and I got registration and then explored into litigations. And after 2-3 years, when we realized that we have specialized into this field and we are not doing anything else apart from this, then I took advocacy, because now I'm not doing any CS work. Because I'm already having that tune of work into particular field and now I specialized into particular field. So slowly and gradually, everyone can identify their area of practice and can grow on that. So RERA is such one of the field. It can be, there are various other options also. So it's completely on the members how to adopt and what to adopt. But I can guarantee it's very good area of practice, because અમદાવાદમાં કોઈ પ્રોજેક્ટ નાનો થતો નથી અને 3-3.5 વર્ષમાં પતિ તો જવાનો જ છે.
Thank you,
Yeah.
Lokesh bhai.
Lokesh bhai, we have 2 questions in chat box. I think Karthik bhai, these are last 2 questions we are taking, right?
Yes.
First is, what are the promoters obliged to do in regards of insurance? So I think you have already answered. If anything needs to be added. The second question is the society are required to register itself at the time of redevelopment project? Is there any rules made by RERA?
So in redevelopment projects, what happens is first at the instance and MOU is executed between society and developer, and then a registered development agreement is executed between the society and developer, and then the developer gets the project registered with the RERA. And while registration of the project with the RERA authority, it is already information or detail is submitted wherein the promoter is required to mentioned that it is redevelopment project, already existing so much members are in the project to whom I will be allocating this number of units. I will be giving this much amount of funds as a maintenance for deposit. I will be giving this much amounts of funds for furniture and extra works. So all such things already comes on the records of the RERA, but registration is required to be done of the developer, because under the RERA, under the promoter definition, 3 persons are covered. The person who owns a land, the person who develops the project, and the person who sells the project. So in such case, when land is owned by someone else and development is done by someone else, like joint development agreements are also done by some landowners and builders, the developer is required to register with RERA. However, all such information and joint development agreements and everything are already submitted before the RERA authorities, and a joint affidavit will be given by the developer and the landowners in the format prescribed by the RERA authorities. So in society redevelopment case, developer will only get registered, but being a society member, what happens is, like let's say ABC society went into redevelopment, a developer came into picture. After that, he had committed to give the units within 3 years. During the period of 2 years, like existing 20 units, new 40 units. So for rest of the 20 units also he has taken the bookings. After 2 years, developer failed to complete the construction and he left the project uncompleted. Then this additional 20 members will also become the member of the society itself for the new project. Now the society will be consisting of the 40 members, and that existing society members will also be responsible for that other 20 members. And whenever the project gets completed with the new developer, that existing 20 additional members will also get their units from that new developer. એટલે જે existing society member છે એ બી જવાબદાર બની જાય છે નવા booking members ને. જો પ્રોજેક્ટ રીડેવલપમેન્ટ ના કેસમાં બિલ્ડર અડધેથી છૂટો કરીને જતો રહે તો. So સોસાયટી મેમ્બર્સ માટે રીડેવલપમેન્ટ ના કેસમાં એન્શ્યોર કરવું બહુ જરૂરી છે કે કેટલું એડિશનલ આપે છે ને એના કરતા પ્રોજેક્ટ પૂરો કરીને આપશે ને. કારણ કે કોઈ 5 લાખ રૂપિયા મેન્ટેનન્સ ફંડ આપતું હોય અને કોઈ 4 લાખ આપતું હોય તો લાખ રૂપિયા કરતા કોનો પ્રોજેક્ટ પૂરા કરવાનો ટ્રેક રેકોર્ડ કેટલો છે ને જૂના કેટલા પ્રોજેક્ટ કરેલા છે ને કેટલા જલ્દી કરેલા છે ને એ ચેક કરવું વધારે જરૂરી છે. અધરવાઇઝ એડિશનલ 20 મેમ્બરની રિસ્પોન્સિબિલિટી બી આ 20 મેમ્બર ઉપર આવી જશે. અહીંયા બી એક એરિયા ઓફ પ્રેક્ટિસ છે કે હવે રીડેવલપમેન્ટમાં સોસાયટી સાઈડથી બી લોકો કન્સલ્ટન્ટ રાખે છે ટુ ચેક ઓલ ધીસ થિંગ્સ. They appoint project management consultancy firm or legal firms to verify all such development agreements, drafts and everything. So this also becomes an area of practice for the legal practitioners or the person who is having a little bit background of land revenue or redevelopment or revenue related works can definitely explore these areas also. And Bombay and Maharashtra, this is a society registration and its regular compliance is a very big practice. Like Ramesh Prabhu sir or Shilpa ma'am, all such names are very famous for that. But in હવે જે time redevelopment નો અમદાવાદ કે ગુજરાતમાં આવી રહ્યો છે, it is giving us an opportunity to explore that kind of practices.
Lokesh bhai, I must say that your desire to impart selfless service in the form of knowledge impartation is commendable. The way you have explained us, and you are so much eager that we learned RERA in a very detailed way, in a very practical way. And I really thank Ashish bhai that the format suggested by them, by both of you, is really excellent, and we have got the praise for the same. So thank you so much, Lokesh bhai. We really enjoyed, and we are knowledgeable as far as the RERA is concerned now. I request Honorable Secretaries C.A. Sridhar Shah to please give certificate of appreciation.
Thank you so much for having me here. Thank you Ashish bhai and thank you everyone for patiently listening me. Thank you so much, guys.
Thank you so much, sir. And again, Sridhar bhai, please give vote of thanks.
It is indeed pleasure to propose vote of thanks for today's webinar on RERA. As per the AGFTC's initiative to cover the allied laws and bringing the new speakers, we had a good experience, very good experience, and a knowledgeable session from Advocate Lokesh Shah, who has not just guided us on the part of provisions of RERA from buyer's perspective. He also covered the part how we professionals can grab the opportunities, in the field of RERA and all the allied matters. It is just a matter of determination, as Advocate Lokesh himself is one of the example that determination can work in a matter that from CS practice he has moved to RERA practice. So definitely thank you, Lokesh bhai, for such a nice webinar and your insights. We thank Vice President ITB Ashish Tekwani for having such a knowledgeable faculty for us, who given us insights on the RERA part. And we thank all the attendees who have attended it. All those who could not attend can see it on the YouTube channel of AGFTC2. Thank you. With this, we end the webinar. Thank you.
Thank you so much, guys, for having me.